Asset freezing is a legal process which prevents a defendant, whether innocent or guilty, to an action from dissipating their assets from beyond the jurisdiction of a court so as to frustrate a potential judgment. It is widely recognized in other common law jurisdictions, and such orders can be made to have worldwide effect. It is variously construed as part of a court's inherent jurisdiction to restrain breaches of its process. The jurisdiction arises in part from the Judicature Act 1873, which provided that a mandamus or an injunction may be granted or a receiver appointed by an interlocutory order of the court in all cases in which it shall appear to the court to be just or convenient. Relying on this, Cecil Mister in 1878 declared, "I have unlimited power to grant an injunction in any case where it would be right or just to do so." The legal order itself is in the form of an injunction, which in Commonwealth jurisdictions is also known as a freezing order. Mareva injunction, Mareva order or Mareva regime. After the case Mareva Campagna Naviera SA vs International Bulk Carriers SA. Although the first recorded instance of such an order in English jurisprudence was Nippon Yuzen Kaishui Karageorges, decided 1 month before Mareva. The Civil Procedure Rules 1998 now define a Mareva injunction as a freezing order. Asset freezing is not a security, nor a means to pressure a judgment debtor, nor is it a type of asset forfeiture, since it does not confer upon anyone else a proprietary interest in the defendant's assets. However, some authorities have treated the Mareva injunction as an order to stop a judgment debtor from dissipating his assets so as to have the effect of frustrating judgment, rather than the more strenuous test of requiring an intent to abuse court procedure. An example of the former would be paying off a legitimate debt, whereas an example of the latter would be hiding the assets in overseas banks on receiving notice of the action. A freezing order will usually only be made where the claimant can show that there was at least a good arguable case that they would succeed at trial, and that the refusal of an injunction would involve a real risk that a judgment or award in their favor would remain unsatisfied. It is recognized as being quite harsh on defendants because the order is often granted at the pre-trial stage in ex parte hearings, based on affidavit evidence alone. To prevent potential injustice and abuse of the court's powers in an ex parte proceeding, moving parties are required to provide full and frank disclosure at such proceeding. The moving party must make a balanced presentation of the facts and law, including all relevant facts and law which may explain the respondent's position if known to the moving party, even if such facts would not have changed the court's decision. If the court is misled on a material fact, or if there is less than full and frank disclosure, the court will typically not continue the injunction. A Mareva injunction is often combined with an Anton Pillar order in these circumstances. This can be disastrous for a defendant, as the cumulative effect of these orders can be to destroy the whole of a business custom by freezing most of its assets and revealing important information to its competitors. And the two orders have been described by Lord Donaldson as being the law's nuclear weapons. Motion for Mareva injunction is also frequently brought together with a Norwich Farmaceuticals order, or more commonly known as a tracing order. A Norwich order is a form of pre-action discovery that allows an aggrieved party to trace otherwise hidden or dissipated assets with a view to their preservation. While it is not advisable to obtain such an order on purely strategic grounds, asset freezing has a persuasive effect on settlement negotiations. While a claimant obtaining an order can expect to face subsequent opposition in court from the defendant, the freezing order is generally considered to be the beginning of the end for the defendant, as they will be unable to defend themselves with very limited, no available income. The claimant will have no restrictions on legal fee spending, putting huge financial pressure on the defendant, and negotiation and settlement avoid the return to court. In many jurisdictions, freezing injunctions brought ex parte are only granted for a very short period, usually a few days. At the end of this period, the moving party is required to return to court to justify the continuance of the injunction, this time with notice to the opposing party, so as to allow the latter a chance to contest the injunction on its merits. Current orders issued by the court do not generally call for a blanket freezing of assets. And they are currently worded in more nuanced terms according to the situation concerned. The process is regarded as a high-stakes exercise for several reasons. Similar provision can be found in the exercise of. It has been extended to oath.